You can remain on the phone, and your attorney can perhaps negotiate with the state and see if the state is willing to do anything. However, a warrant is going to be issued for your arrest.
Okay.
All right. Do you need to speak with her? But you have her phone?
Right, I have a phone, Your
Is
Honor.
this going to end up being a contested hearing?
Yes, Your Honor. And that she could, okay, one issue I have is right now. We just filed it. They just filed it.
This is not going today. My question is whether or not it's going to be a contested hearing. It's not going
No,
today.
it's not.
No. So,
Another issue is bond. And apparently when you file the MPR and Your Honor signs it, turns into a warrant, does it not?
yes, it does.
Okay, so now she had no idea.
The judge has heard countless excuses before, but here's the shocking legal bombshell. Skipping probation orientation is legally treated as never starting probation at all. That single careless mistake instantly turned into a warrant and possibly many long years behind bars. Would you honestly call that fair?
All right, Ms. Ferguson, can I have a 15-day reset for a contested hearing?
So do I have to turn myself in?
You need to speak to your attorney, but there's a warrant out for your arrest.
They didn't tell me any of this.
All right, well, allegedly, you've never reported for probation.
Definitely tell them that's there.
All right, so it's going to be reset for October 24th. What time?
Okay,
At 9
so
a.m.
is there any way to get it for November? Only because I'm out of state. As soon as I had bonded out, I had moved with my dad trying for me and my kids, have 5 little girls. I'm trying to do everything I can possibly right to stay straight, to not get in trouble or anything. And with a warrant, I have 5 children. I'm a single mother.
Well, here's the thing. Allegedly, they're saying that you have never reported. So, I mean, they're saying you never reported.
And there's no way to get that MTR lifted.
You need to speak to your attorney.
I've tried, and this is the first time I've even seen my attorney.
Well, here's the thing, Miss Garcia.
Yes, ma'am.
The first time that probation allegedly is seeing you. And I do believe that allegedly you probably don't have permission to have left Bexar County.
Yes, they told my dad when my dad had helped bond me out.
No. Here's the thing. I don't need to hear about your case. I'm just telling you that your court date is going to be on October 24th. A motion to revoke has been filed. If you would like to speak to your attorney by phone and your attorney has your phone, you can remain on the phone, and your attorney can perhaps negotiate with the state and see if the state is willing to do anything. However, a warrant.
Okay.
All right. Do you need to speak with her? But you have her phone?
I have a phone, Your Honor. I can zoom in.
All
Out there.
right. Oh, sure.
I'll zoom in.
All right.
I just need the ID numbers.
All right, Ms. Ferguson, if you could,
Is that all, Your Honor?
no, you're to stay online.
Okay.
And Norma, I'm saying it to you. Oh, this one.
I'm here for Amicus Garcia, who's supposed to show up for her FCR hearing, contested hearing. Apparently she didn't show up.
All right.
I did talk to her over the weekend. She said she was on the way. Remember, she had left the state of Texas, gone to
Yes.
Missouri somewhere, that she was coming back, but obviously she's not here.
All right.
So I've been waiting for about 45 minutes.
All right. We're going to go on the record. Can I have someone from the state on Amethyst Garcia, please? Court is calling 2021 CR 2958 and 2022 CR 8569, State of Texas versus Amethyst Garcia. Can I have parties announced for the record for the state?
Pretty start.
Defense?
All
right. This hearing was scheduled at 9 a.m. It is now 9:55 a.m. Deputy Laura, is there an Amethyst Garcia outside the courtroom?
No, Your Honor, she is not.
And she is currently not in the courtroom either. Counsel, where's your client?
I talked to my client over the weekend, Your Honor. I reminded her about coming to court, that it was in person and that she needed to be here, that she was on her way into Texas. And I said, okay, then I'll see you on Monday, and that's as far as it went.
All right, state.
Notice carefully how her attorney leans heavily on personal tragedy, the devastating loss of her grandmother, her brother, and the overwhelming weight of raising 5 daughters. But does heartbreak truly outweigh accountability? Should modern courts balance human sympathy with strict enforcement? What's your genuine take?
Okay.
I believe so.
All right. Well, the court will issue a bond forfeiture and remand your client without bond. If your client makes an appearance, then the court will reconsider. 2 CR 8569, State of Texas versus Amethyst Garcia. Can I have parties announced for the record for the state?
Go ahead, Your Honor.
And are you Ms. Garcia?
Yes.
Ms. Garcia, in cause number 2022 CR 8569, you entered a plea. And according to the plea bargain agreement, punishment is to be assessed at a cap of 5 years in the prison. There's a $1,500 fine. State is silent on your application. They're taking in consideration NIMAG number 688702. Have both parties had a chance to review the PSI report?
Yes, Your Honor. With my understanding that the cap was at 4, unless I misunderstood.
No, I'm just reading what's in the,
My understanding is cap of 5.
5.
Yes.
Okay.
all right. And then Ms. Garcia, I'm going to show you what's entitled motion to revoke community supervision and state's motion to supplement pending motion to revoke probation. Did you review those documents with your attorney? Did you understand them? I can't hear you.
Yes, ma'am.
Are you the same Amethyst P. Garcia who's placed on community supervision in 2021 CR 2958 for the offense of possession of a controlled substance, penalty group 1 gram or 4 grams on April 18, 2022 for a term of 5 years?
Yes, ma'am.
Violated condition number 1 on or about the 9th day of June 2022, in Bear County, Texas. The defendant, Amethyst P. Garcia, committed the offense of possession of controlled substance, penalty group 1, 4 to 200 grams, in violation of condition number 1.
How do you plead to that? True or not true?
True.
Your Honor, we'll waive the remaining violated conditions.
All right, did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, and sentence you up to 6 years in prison and up to a $1,500 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, ma'am.
Court will find violation of condition number 1 true. I'm assuming there is no agreement on the motion to revoke.
That is correct, Your Honor.
All right, and the state is silent on 2022 CR 8569. In that cause number defense, do you have any witnesses?
Oh, yeah.
All right, then the court will hear argument.
Well, on the, are you saying for the application for probation?
Yes.
Yeah, the application for probation. Now, when we were trying to negotiate all of this MTR and everything, so my understanding is, and of course, right now I'm saying it's different, but my understanding is that the MTR agreement for the for punishment would be to run concurrent or to run together with the case that she plead on. So that's what, on that new case, Your Honor, we're asking this court to give her another opportunity. Now, she did not comply with her probation. In fact, she, as Your Honor can read, she didn't even start her probation. She didn't show up for orientation or anything like that, which caused the warrant and everything to come in. Now, she's realized she's been in jail since November of 2022. She realizes that this has to stop. And she picked up a new case. It doesn't get any better, because it gets worse as you go along. However, I'm asking this court to give her another opportunity. And why should you give her another opportunity on probation is because I think that she realizes that this has to stop. She had a death in the family of her grandmother last year. That was her mother figure. She lost a brother who also contributed to her mental state, which made her bad judgment. So, we're asking the court to give her the opportunity to, go on probation, do things right, go back, because she's got 5 daughters to go home to, which are in the hands of their family. She has a father that is there, that is willing to support her, and she also has a job that's waiting for her if when she gets out, Your Honor. So we're asking the court to give her the opportunity. It's a second opportunity. I know that the facts in her case.
Notice how her attorney leans on personal tragedy, the loss of her grandmother, her brother, and the weight of 5 daughters. But does heartbreak outweigh accountability? Should courts balance sympathy with strict enforcement? What's your take?
TAP evaluations are recommending SAP, and SAP right now is, I know it's a long waiting list, and it'll be maybe a year, a few months before she goes to SAP. But we're asking the court to follow the other alternative, which is the outpatient treatment, and put as many requirements on her for her probation to do the outpatient treatment. That way she can go to work, she can go take care of her children, and she can prove to this court that she, and I'm not saying she learned a lesson, I'm just saying she had learned that she has to stop. That's the only words I can come up with. She has to stop. She has to grow up and be there, a parent for her children. And I'm asking the court for probation.
All right. So anything you wish to say, Ms. Garcia?
Yeah, it shouldn't have used it, is it?
All right, do you want to raise your right hand? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God? You can lower your hand. You're gonna have to make sure you keep your voice up. State your name for the record.
Amethyst Garcia.
All right, what would you like to say?
That I apologize, that I was in the wrong, that I used an excuse when it's not an excuse, and I've acknowledged that now. I'm not saying that, oh, no, that's the time. No, I know that I have to do what I need to, and I do have 5 daughters, 9, 8, 7, 6, and 5. And I need to be there for them. I do have a job lined up. I do have support from family, and it's time to go on with my life and to carry on and do what I need to do as a woman, as a mother, and do what I need to do.
All right. Ms. Garcia, I'm looking at your criminal history. And sometimes people are learning their lessons, but your criminal history is not good. And when I look at criminal history, I'm not necessarily looking at it to say, oh, this person is a bad person. I'm looking at it to see, has there been any type of intervention? Has somebody learned their lesson? Is there anything that I can do to protect the community and have this person be an, productive member of society? And I'm looking at your history, and there have been plenty of interventions for you, and you have not taken advantage of any of those interventions. And I don't think probation is appropriate for you because of that. And because of other things that are in the PSI report, the fact that I previously had you on probation to work with you. And I think any defense attorney in this courthouse, in this courtroom, will tell you that when I put people on probation, I'm hoping that they will be successful, and I give them conditions to have tools to be successful. And I always ask people when I place them on probation, I always ask them, is there anything else they need from the court to be successful? And what you've done since you've been on probation is not report. You just picked up new charges, and I can't have that. All right, the court is going to sentence you to a $1,500 fine, time and money. I'm sorry, cause number 2022 CR 8569. The court will sentence you to a $1,500 fine, time and money, and run concurrent. This will run concurrent with 2021 CR 2958. 5 years in the prison. Take in consideration NIGHTMAG number 688702. give you credit for any time served. All right, and we'll do a request for therapeutic community. All right, next we're going to move on and cause number 2021.
The judge's final ruling was crystal clear and absolutely firm. 5 long years in prison, steep fines, and probation fully denied. Despite her emotional pleas, the court strongly prioritized community safety over offering second chances. What's your honest take on this ruling? Drop a thoughtful comment, hit like, and subscribe for more intense dramatic courtroom moments.